Chapter 11, the Supreme Court. What powers does the Supreme Court have in its battle with the President and Congress? Well, the first thing you could say in terms of the powers of the Supreme Court is that it has more prestige than the President or Congress. Usually this is because the Supreme Court is less well known than the President or Congress. In this day and age, now that we're in the 21st century, there's so much media coverage of any negative things that happen with the President or Congress. But the Supreme Court seems to be more like what politics was like in the 1950s and 60s, before the public really knew all the picadillos and problems and issues that faced the President and members of Congress in their personal life. So the end result is, because the public knows less about the Supreme Court, they tend to have higher amount of prestige, and it can go a long way in terms of the willingness of the public to accept what the courts say. Second, there's a sense that the Supreme Court is not as political as the President or Congress. The Supreme Court pretends not to be a political branch when they make decisions, even very highly controversial decisions. They tie it back to the Constitution. They make it sound as if they're just following precedent. They're making it seem like this is what's in the Constitution. I think it was Justice Black who said, I don't really have to interpret the Constitution, something to the effect like this. I carry the Constitution with me all the time, and I don't have to really interpret it. All I have to do is read it, and then I know how to decide cases. Well, nothing really could be further from the truth, but if the public thinks that these guys are trying to be objective, and that carries over from other courts, because most judges in most courts in the United States, whether they're national or state and local courts, there's a tendency to try to be objective and neutral, and not to make it seem as if you're favoring one side or the other, not to make it seem as if you're just like the Democrats favoring other Democrats, or Republicans favoring other Republicans. I remember when I served on a jury when I was living in Chicago, and it was a trial having to do with a malpractice case in terms of a doctor who operated on a person. And after the case was over, the jury gets to talk to the judge and the lawyers in the case, the lawyers who tried the case. And I happened to be the foreman of the jury, and what happened then was I was asked into the judge's chamber, and the judge said, "You guys made the right decision." And he also asked me a bunch of questions about how he was perceived, whether he seemed to be neutral, and he tried to really present himself as somebody who didn't favor either side. And he was real big on that, to make sure his body gestures and body language and all that didn't reflect favoritism. So that's kind of how we think of the courts anyway. So it's not surprising that they would be seen as less political. And if you just look at presidential campaigns or congressional discussions, they're very, very partisan. The Democrats almost always favor whatever position the president takes because he's a Democrat, and vice versa. The Republicans are going to almost never give the president credit because he is a Democrat, especially at this time of the year, because now we're in a situation where we're in a campaign for who's going to be the next president. Another power that they have is judicial review. Now, judicial review is the right established, as I mentioned before, in Marbury versus Madison, that gives the Supreme Court the right to decide what is constitutional and what isn't, which includes laws passed by Congress and actions taken by the president. So that's a pretty powerful rebuke. It can be a very powerful rebuke of both the president and Congress. So if the president does something that appears to be unconstitutional according to the judges, they can stop him or change his action. What comes to mind is, for example, when President Nixon was president, Congress, under the powers of attempting to supervise the executive branch, asked President Nixon for the tapes that were recorded in the White House. Once it was discovered that the president was taping all the people who came into the White House and came into the Oval Office, I should say, in the White House, that there was recordings of all the conversations, and Congress was investigating Watergate. They asked the president for the tapes, and the president said no, he wasn't going to give them up. Separation of powers and the right of the executive to maintain itself free of the legislature indicated to him that he didn't have to give them up. Well, the Supreme Court in U.S. versus Nixon required the president to give up those tapes, and that was under the concept of judicial review. He was then forced to turn over the tapes, and one thing led to another, and before you know it, he was resigning. So the power of judicial review had a lot to do with that, by forcing Nixon to give up the tapes. Then the last thing I would say here is that they're the final judge in the system. We have a judicial system that starts at the bottom with district courts and goes all the way to the Supreme Court. So cases that eventually make their way to the Supreme Court usually means that that's the final arbiter of the case. That's your last chance in the system. And that's a powerful aspect related to the Supreme Court as well. Okay, number 2, why is the Supreme Court considered the weakest branch? Well, it's considered the weakest branch essentially for the following reasons. Number 1 is they must rely on the president to enforce the law. Now, they can say something, they can have a ruling, and the end result would have to be that the president would have to be the enforcement through the Justice Department or through the Attorney General's office. Somewhere in there, the president would have to order compliance. A classic example of this is prayer in public schools. It took the Supreme Court about 25 years to clearly delineate a law, and that's one of the problems of the Supreme Court, that it takes a long time to really develop what we would consider to be a general rule or law. So when they started to deal with prayer in public schools, it started out with a case that had to do with what was called the Regent's Prayer in New York, where this was put together. The prayer, which was going to be used in public schools, was put together by kind of like a consensus of the major religions at the time, Protestant, Catholics, and Jews. So they put together this prayer, and it was acceptable to the Protestant, Catholics, and Jews, and so they're going to use that. And Supreme Court basically said no. And it went on and on for years, different kinds of prayer in different situations within the public school. Eventually it got down to silent prayer, where you just bow your head for a second, and the Supreme Court even said that was not constitutional. So they get this ruling that makes it pretty clear after 25 years that there's no such thing as a allowable prayer in public school. But the President of the United States never really attempted to enforce that thing. Mainly in the South, in the Bible Belt area, it was just ignored. And so that's the kind of thing that happens. The Supreme Court will make a ruling, require integration of all public schools, or, like I said, no prayer in public schools. And and unless the president gets serious about really enforcing it, it's not going to happen. And that's kind of what happened. That's basically it. I mean, there was a lot A lot went on in the 1950s and 60s when the Supreme Court required busing of students so that schools would be integrated. And yet, when you got to our time, into the end of the 20th century into the 21st century, less than half the schools were ever integrated. So again, that's a weakness. You have to rely on the president. The president's only going to do it if he really agrees with what the Supreme Court has said. And if he doesn't agree with it, he'll just ignore it. Issues are almost never solved in one case, and that's really, really true. More recently, you had a situation that developed out of Chicago with gun control. And the Supreme Court reversed itself. For years and years, the issue of gun control was that the governments had a right to restrict an individual's right to have a gun. That the right to own a gun or to have a gun was not an individual right, it was a collective right. That's what the Supreme Court had said all the way through the history. And then we get this famous case that comes out a couple of years ago in Chicago that the Supreme Court reversed itself and said, no, it's an individual right. So now everybody has a right to a gun. And the Supreme Court's saying that. But in cities like Chicago, where there's very strict gun laws, very few people can ever get a permit. That really never changed because, again, that's an issue that doesn't just face the president, it faces local government, police, and so on. And the police don't want to make it easy access to guns in Chicago. It's one thing to have weapons in places that are not highly populated, like rural areas or rural states, like small places like New Mexico. But it's another thing to have big cities where everybody's toting some kind of gun and they're doing it legally. So what happened is that the issue wasn't really solved. I mean, like the extent to which cities could restrict gun ownership was never really solved in that case. It just was, the principle was established that individuals had a right to a gun. So the issue wasn't solved, and basically, since the government, in terms of the city of Chicago, doesn't want people to have guns, they never really loosened up, even though the Supreme Court made those decisions. Now, it's going to be probably much like any other situation, like prayer in public schools or some other issue, that it's going to take a long time before the court would ever solve it in terms of making a clear ruling that individuals have a right to carry a gun or have a gun. And probably by then the Supreme Court may have changed and the ruling won't survive. So it almost never comes down to one case. It has to take several cases to make a law, and oftentimes that never really happens. So that's a weakness. They're a passive institution. The courts are passive. That is to say, they don't just make laws like Congress would do, where some member of Congress would initiate the idea. They're passive. They have to wait for a case to come to them. If a case never comes, they don't rule. So they're in a much worse position or weaker position than, say, Congress or the president when it comes to deciding what to do. Another weakness is precedent, that is, relying on past decisions. The Supreme Court tries as much as they can to rely on precedent. If there is no precedent, that's different, but they generally do that, although sometimes they will deviate from that. Classic example is that case of Gore versus Bush, when the presidency of the United States was not really decided based on counting the votes, and the Supreme Court, in a 5-4 decision written by Scalia, decided to give the presidency to Bush. Now that was a violation of precedent, because as long as I can remember, every case that we've ever had that dealt with an election, the Supreme Court called it a political question. That is to say, this does not belong to us, the Supreme Court. This belongs to the political branches to make a decision. And nowhere at any time did the Supreme Court ever try to determine what an election would be. They would maybe say the election wasn't clearly delineated, or there wasn't a way to count the votes. So in that kind of case, which I expected would happen here in Florida, that the Supreme Court would say you have to hold the election again, and count the votes again, try to do it over, just like you reorder a trial when there's mistakes made by the judge, or there's new evidence in a case. They would reorder a trial. But in this case, they went against all precedent and just said Bush is the president. Another thing that weakens them is that they're almost never unanimous. There are very few decisions that are unanimous decisions. They tend to be 5-4 decisions. That means one person is really the deciding vote on the courts. And that creates a problem, especially for those people who advocate for democracy, trying to argue that 9 people should be able to make the law for the rest of us. And in many cases, like the one I just mentioned on Bush versus Gore, only 5 judges made the decision. Number 3, how does the president attempt to control the Supreme Court? The president has 3 methods. One is to appoint judges. The president doesn't do it by himself. He has the advice and consent of the Senate. That is, the Senate has to approve the appointments. But the president nominates somebody, and that's a powerful position. And if you look at the people who get appointed, they tend to be the same ideological, philosophical position as the president. So the people who get appointed by a Democrat tend to be at least Democrats, or Republican, they tend to be Republicans. More conservative judges are appointed by Republican presidents. More liberal judges are appointed by Democratic presidents. So that's a pretty important thing. If there was an opening, it's very possible, just like with one appointment to the Supreme Court, the president could change the Supreme Court. But that would require the right kind of person. That is, like for example, right now the court is dominated by the 5. So 5-4 is generally conservatives who make up the 5. They're conservative, and it would require one of the conservatives to retire for Obama to have the power to appoint somebody else. That would switch the power of the courts. So the 5 would then become liberal rather than conservative. But that's not likely to happen, because even if a person is sick or dying or something, they generally hold on until the next president is appointed. Even in case of Judge Ginsburg, who seemed to be in very frail health, she hung on. Although if she quit, it wouldn't really make a difference. If the president appointed another liberal in her place, it wouldn't change the balance. But I was surprised to see that she didn't retire, because I thought she retired during the Obama years so that Obama could appoint somebody else. But there's a lot of prestige to it, and people, in this day and age, a lot of people don't want to retire, no matter what they're doing or how bad a physical condition they're in. So anyway, I was surprised she didn't retire, but she's hanging on. She's still there. And now we'll see what happens in the future. Another thing what the president can do, and I mentioned this before, is enforcement. That the president can decide, is he going to enforce the rulings of the Supreme Court or not. It's a very delicate political position that the president can be put in. Like, for example, when I mentioned a prayer in public schools, the president's not going to want to go send law enforcement officials down into the Bible Belt and break up a prayer or something like that that's going on in a public school. That would be highly embarrassing to the president or the Justice Department or the Attorney General. So the end result is that that kind of thing is ignored. The more political it is, the more likely it is to be ignored. And then the last thing is public campaigns on behalf of the issues. That the president, has the opportunity to get in the media give speeches and talk to the public and go on um, talk shows and political morning shows on Sunday and talk about the issues, talk about the Supreme Court. You could even do, although it wasn't successful, you could do what FDR did when the Supreme Court started to use judicial review against his New Deal programs. He advocated to change the court, to increase the number of members so he could get a majority that way. That wasn't successful, but the president's, any publicity given to the courts could have an effect, especially if the president's a popular person. So those are the three techniques that the president can use: appointment, enforcement, and publicizing the issues. Okay, the last one is, why is the Supreme Court considered different than judicial branches? For one thing, the procedures are different from other courts. You've got the 9 judges sitting up on the dais, and then you have attorneys appearing before them one at a time, and the judges, first of all, the attorney who's presenting a case has lights in front of him, and there's like a red light and a green light, and when the green light's on, he can keep talking. When the red light goes on, he has to stop talking, and during that time, the judges can stop him and ask questions, and it's a very different kind of procedure. You don't have the typical kind of courtroom drama that you see on television, where you have defendants or lawyers or people taking the witness stand and presenting testimony. You don't have any of that stuff. You just have basically the cases are presented as briefs in writing before the case begins. The judges read them ahead of time, and then you get a chance for oral argument or a presentation on the side of each attorney, and then a lot of questions by the judges during the course of the presentation, a lot of interruptions of the judges. So this is a very different kind of court than you have at the other levels. It's a court of last resort. That makes it different. There's no other place to go after you get past the Supreme Court. They deal with major controversial issues, oftentimes issues that the other branches don't want to handle. For years, what will happen is that a case will involve some serious problems in the judicial system, some serious problems in the society, like when people's rights are being denied, like the right to vote. When black people were unable to vote, these kind of cases then affect the whole country, and therefore the Supreme Court will get involved in it. Oftentimes they wait for the political branches, Congress in particular, to handle something, but it doesn't happen, so the Supreme Court jumps in. That's why you have issues like campaign finance reform. That kind of issue makes it to the Supreme Court because Congress really isn't going to handle it, because they don't want to deal with it. The president doesn't want to deal with it because all of these people are getting a lot of money from interest groups. And then the last one is that there's more prestige. It has more prestige than any other court. I mentioned that before as well, that the public doesn't really pay attention to what's going on much in terms of the courts, and therefore they have higher prestige. They don't have the kind of scrutiny that's given to members of Congress or given to the president. So here's a picture of the current court. I mentioned Justice Ginsburg. She's the one sitting on the far right. She looks pretty frail there. She's a small woman anyway, but she looks like she weighs less than 100 pounds. She's been battling cancer for quite a few years now. Chief Justice is in the middle, and then you have the women. So there's 3 women on the Supreme Court, 2 women standing up in the back. If you look at the next slide, the Supreme Court in gay marriage, here's the judges, the 5 judges that voted for gay marriage, and you have the 3 liberal judges who are the women. All 3 of the women are liberals. And then you've got Breyer, who's the one next to Ginsburg, and then you've got Kennedy, next. So that those are, kind of like what has to happen in order to get, for the liberals to win anything. You have to have at least one or two of the more conservative, or I should say less conservative judges to go along to get a 5-4 decision. And that's what you had in gay marriage here with the two conservatives joining up with the liberals. Okay, so here's a diagram of most liberal on the left here to less liberal or more conservative judges. So if you look at it, you have Hagan, Sotomayor, and Ginsburg, the three women who are liberals, and you can count on them to be, to decide on a liberal side of the issues. Then you have Breyer, he's conservative, but he's less conservative than any of the five bunch over here. Kennedy, usually it's Kennedy is seen as the swing guy, and then you have the four judges that are real conservative: Roberts, the Chief Justice; Scalia, Thomas, and Alito. According to this map that I picked off the internet, Alito's the most conservative of all the judges, but they're all Roberts, Scalia, Thomas, and Alito are all pretty conservative. I would say Breyer and Kennedy are conservative too, although on some issues they're willing to move. So if Breyer, he's sort of, in terms of the way these judges look, he's sort of on the liberal side. So you can kind of count on him to be in the 4-against-5 decision. And then the key man, the one vote that really counts, is usually Kennedy, who can go either way. Although you never know. Some of these judges sometimes they're libertarian more than they're conservative, and you just never know what's going to happen. It makes for an interesting Supreme Court. Now here's another diagram that shows like how connected they are. So if you see like these thicker wires or lines or whatever between the judges, you can see that the three women, Sotomayor, Ginsburg, and Hagan, really vote together almost all the time. So that their wires there, connections are wide bands. And you see the same thing when it comes to the conservative side. You've got Scalia, Thomas, Alito and Roberts are pretty thick. The wires connecting them are pretty thick. In other words, they vote together almost all the time. And then there's an occasional, but not often, times when, say, Scalia will match up with Ginsburg or any of the other possible combinations. So you can see the conservatives generally vote together and the liberals tend to vote together. That's all it's really saying. With these two guys, Breyer and Kennedy, as the swing votes. Here's Supreme Court ruling on health care, the Obamacare, whatever you want to call it. And again, you can't always tell how people are going to go. Here you had the five that voted for it were Roberts this time, who's a dying-to-wool conservative. Breyer, that's not unexpected, and then the three women. And against it were the conservatives, and Kennedy was not a swing this time. So as Roberts was a swing, which is kind of surprising. Anyway, that's, like I said, it's something you don't know will happen.